All right, today we are jumping into the really complex legal lines that are drawn around federal immigration enforcement right here in the United States. And this is a topic that you'll see touches on some of the most basic principles of constitutional law.
So just imagine this for a second, because for a lot of people, this is not a hypothetical. There's a knock on the door, and on the other side are federal immigration agents. What happens in that moment isn't just about policy, it's about fundamental constitutional law. And that one question, it's really the key to this whole thing.
So yeah, let's start right there, at the front door. Because this is the exact spot where a major tension in American law plays out every single day. It's the government's power to enforce immigration law, bumping right up against the constitutional rights that protect every person inside the country.
And honestly, it all boils down to what seems like a simple question. But understanding the legal difference between a request and a command, well, that's everything. It defines the limits of power for federal agents, for local police, and it determines what your rights are in that moment.
So that leads us right to the most important legal tool in all of this, the warrant. And as you're about to see, not all warrants are created equal. Not even close. This one distinction changes everything.
Okay, so first up, you've got what's called an administrative warrant. The best way to think about this is that it's an internal document. It's created within an agency like ICE, and it gives their agents the authority to arrest someone for an immigration violation. But, and this is a huge but, it's only valid in public spaces.
And here is where it gets really, really important. That administrative warrant, that's made in-house. A judicial warrant, on the other hand, has to be signed by a neutral judge, and it has to be based on probable cause. So the bottom line is crystal clear. An administrative warrant cannot be used to force entry into a home. Only that judicial warrant, the one signed by a judge, is the actual legal key to that door if you don't give consent.
And look, this isn't some new hot-take legal theory. This is, as the sources all make incredibly clear, settled constitutional law. I mean, we're talking about the Fourth Amendment here, the one protecting you from unreasonable searches. Courts have affirmed this distinction time and time and time again.
So, just to be absolutely clear about it, the law allows only 3 ways for federal agents to legally come inside a private home. That's it, just 3. Number 1, they present a judicial warrant signed by a judge. Number 2, they get knowing and voluntary consent from the person who lives there. And number 3, there's a true emergency, what the law calls exigent circumstances, like they're in hot pursuit of a fleeing suspect. That's the whole list. There is no number 4.
Now let's zoom out a bit. Let's take these rules that apply to a single front door and see how they play out on a much bigger scale, at the city and state level. And this is where you always hear the term sanctuary policies come up.
A huge part of this debate revolves around a document called an ICE detainer. So here's how it works. Let's say a local jail has someone in custody that ICE is interested in. ICE sends over this form. It asks the local jail to hold that person for up to 48 hours after they were supposed to be released. This gives ICE a window of time to come and pick them up. And here we are, right back to our main theme. Legally, an ICE detainer is a request. It is not a command. And that seemingly small distinction, it means everything. It means a local police department is not federally mandated to honor it. They have every legal right to say no.
So why can they say no? Well, it goes back to a big constitutional idea called federalism. The basic idea is that states and cities can't actively, block federal agents from doing their jobs. But, and this is the key, they don't have to help them do it. They can refuse to assist. This is the constitutional foundation for sanctuary policies. And get this, when the federal government has tried to force cooperation by, say, threatening to withhold funds, courts have consistently stepped in and shut it down, calling it unconstitutionally coercive.
And here's the real kicker. It's not just that local jurisdictions can refuse these requests. Federal courts have found that if a local jail does honor a detainer without a judicial warrant, they themselves could be violating the person's Fourth Amendment rights. And you know what that means? They could get sued. So for many local agencies, refusing the request is actually the legally safer option.
So, you might be wondering, why do all these rules exist? They are all built on one foundational principle, about who, exactly, the Constitution protects. And that principle is this. The rights laid out in the Constitution, like the Fourth Amendment's protection for your home, they apply to every single person within U.S. borders. It doesn't matter if you're a citizen, a tourist, or an undocumented immigrant. The rights are tied to the place, not the person's status. Okay, so let's quickly recap what this means in practice. ICE can lawfully arrest people in public using their administrative warrants.
They can ask for consent to enter a home, and they can enter with a proper judicial warrant. What they cannot do is force their way into a home using only that administrative warrant or a removal order. And any consent they get has to be genuine, not the result of coercion or trickery.
So after looking at the law from the front door all the way to the city jail, what is the ultimate constitutional bottom line here? What's the big takeaway?
It comes down to these three non-negotiable facts. First, to force entry into a home, federal agents need a warrant signed by a judge. Period. No exceptions. Second, the principle of federalism means states and cities can legally refuse to participate in federal immigration enforcement. And third, these rights protect everyone on U.S. soil.
Legal experts are unambiguous on this point. Any internal policy suggesting an administrative warrant is enough for a forced entry is, in their words, legally indefensible. It's a direct contradiction of established Fourth Amendment law.
And that leaves us here. The constitutional boundaries we've explored today are remarkably clear and well established in the courts. The enduring question then isn't what the law says. It's about the gap between those clear legal lines and what actually happens on the ground, at the door.